to the regulation, the General Data Protection Regulation. What I told before regarding the directive is the same here. The deadline for tabling amendments remains the 27th of February. And I will give now the floor to Mr. Albrecht, the rapporteur.
Ja, vielen Dank, Frau Vorsitzende.
Thank you very much indeed, Chairman. Similar to what we were saying on the directive, I'd just like to link on to what we've already discussed together in the first round of the debate. Where are we coming from when we talk about reform? What was the aim of the regulation? Well, I think it was basically that something we called for several times in the European Parliament. Last time in our resolution, July 2011, that is based on the information of the last decade and a half with the old directive. We have learnt that the varying types of implementation of data protection law in member states has meant that basic protection is not given to the same degree in all member states. So that gives rise to quite a degree of legal insecurity, particularly those who have their data being processed, but also that's relevant to people who process the data. So we've got to work for more security, legal security, on a simplified basis. We've got to have one rule which is valid for all member states and not have 27 different types of law. That's why we have to greater harmonization. In the past it wasn't possible. So I think what we've got to do, it's important to try and do that now, because it's an area where very probably, more than other areas, you're going to be dealing with cross-border things. 1995, internet was not mass media. Now, pretty much everybody is online all the time. Somebody's linked into the World Wide Web somehow or other. That goes for business people, that goes for authorities, that goes for consumers, individuals, citizens. And I think it's important at the outset we say that the aim is obviously some sort of greater harmonization. That's a challenge, because we have various types of interpretation, different cultures of data protection, so it's going to be difficult to get to compromises. An example, when we look at data protection officers, where are you going to ask the person to be active and how? Are we going to have to be very open to compromise, all sides, all parties to this? So we have got to continually try and make quite clear we don't want to have something which is completely new. We're building on the basis of the development of law and case law rulings over the last 25 years in the various member states, and also international rulings. We have 108, the Council of Europe, which has played a very important role in data protection in Europe. And if we were just to completely forget about basic principles which we established so far, the definitions and principles which we have in the directive and in the regulation have got to be basically following along the line of what we already have in data protection. They've got to be more precise. So at the end of the day, we have a regulation which every man and woman of the European Union can actually use. That's a major challenge. And I would hope that's a challenge we'll all bear in mind when we come up with amendments. I stress that for the Commission again. In many areas, what we have in July resolution 2011, I mean, we're going along the same lines, and We have lots of articles and recitals which are trying to make sure it's not just one size fits all, but in order to try and echo the multiplicity, fill gaps which still have to be filled. And as I say, that's a difficult task. When we came up with our changes in our review, in our definitions, we want to make clear that the rulings we've had piling up over the last few years are actually expressed in the text, in particular when it comes to personal data. It's a point of principle because the decision of what is personal data is basically something which has to be involved in this. When it comes to, say, processing of personal data, it's important to define what that is. That's important for citizens, for companies and authorities, because from that will ensue the various legal ramifications which are relevant. So, major challenge looking at the rights of individuals and the duties of data processors, the authorities, have got to be done quite. We've got to have clear definitions. We do that by saying we've got these goals, these are our principles, and those are mirrored in how we define the rights of individuals, particularly the right to get information, information deletion, information correction. These are important things which we have expressed in the regulation, but it's also mirrored in the duties of authorities, companies and the processors of data, because they have got to do what is legally required for meeting rights, information and that sort of thing. They have to do the necessary to also bear in mind the rights of the individuals. So that's the second thing we looked at. You can see that when you look at right to information. We pruned it down to what is absolutely essential for people involved to avail themselves of their rights. Reduce the amount of documentation down to what is absolutely necessary for the processes to be able to show that they have kept to the rules which have been defined. Obviously that follows on the basis of current law. It's not rocket science what we're doing here. It's a labour based on what we've already got, and drafting that in such a way that they're more precise and fairer. Now, another thing which is a challenge which people are looking at very closely is one-stop shops, single point. When it comes to interpretation, understanding and implementation of this data, who is responsible? Who will be the data protection person? And if there's conflict, who will be the final person who settles a dispute? So we want to keep the one-stop shop. That's very important for us. To say every processor has one data processing officer who keeps an eye on him, and he reports to, who's responsible for what he's doing, make sure that the measures which he takes are correct, and would cover the possibility of legal dispute. And each person who is subject to or somebody who wants to have their data protected would have a contact person, this one-stop shop, to whom they can go, a data protection person. So working together you can get to a common solution, to a common settlement of a dispute before going to real conflict. That happens already. It's only if there is a real conflict that the Data Protection Committee perhaps will be looking at this and then have the option as a last resort to come to a decision which the data protection officer is responsible for implementing this will have to follow. And at the very last resort, if the data protection officer doesn't follow it, a two-thirds majority in the committee, they can force the officer to implement their decision. So it's not the actual nth degree of what we wanted, but we didn't want it always to be the European Commission, in the last resort, can overrule the decision of a data protection officer. It should be the courts or legislator, that's the parliament, say, who would decide as to whether change is necessary to the law or not. And I think that's logical because the independence of data protection people is thereby guaranteed. But we always have a dilemma in any proposals because it's quite clear that it's only the legislator who can come up with rules. We'll do that with this resolution and delete a lot of delegated implementing acts and come up with our own legislation. And it's a data processing officer who would have to interpret the legislation and implement it. But obviously people have different approaches to this. I think it's the best way not to have all these implemented and delegated acts. But I think we want some sort of unification and unified implementation. That's the end goal. And that should be prime. Unified implementation of law basically is to give legal security, as I said right at the beginning, with a regulation which we are designing here, and have a system which is consistent and coherent in its implementation and gives guarantees. So that's what I wanted to say. I said that in the first round too. I'm very pleased to see possible amendments which might improve the whole thing. I'm sure we'll discuss it further amongst the rapporteurs and shadows. And then, I know it's a very complex set of things, but I hope we'll be able to sort of forge it into some sort of votable mass. It's a huge challenge. And I say this to colleagues who are involved in this, please focus in on those parts which are absolutely necessary and which really do need changing. Because we've discussed a lot of things already beforehand. So if you amend, please get together with the shadows of the group, make sure that you agree that it is crucial and essential. Because the whole thing is so complex already that I'm sure with amendments it's going to be more difficult, but at the end of the day we want some votable package. So communication amongst ourselves is crucial when it comes to moving amendments. That is key to the whole thing. We want to make progress, we want to settle the matter before we go into the next electoral term and the elections. Thank you.
Danke, Herr Albrecht. Herr Voss.
Ja, vielen Dank und ich möchte direkt...
Thank you very much indeed. I'll just begin where Jan Philip left off. Obviously, we need to build on the improvements we've been discussing, and I think that we can do this in a collaborative way, whilst remembering that what we're trying to produce is a realistic arrangement which can be applied in practice. We need to have a comprehensive arrangement which will protect the fundamental rights of individuals, and we need to have arrangements which give them protection but also give them enough scope for personal development and personal fulfillment. Therefore, if we regulate data protection in too rigid a way and in too definitive a way, we've given an individual so much protection that they aren't free to do anything anymore, and that is of no avail to them. Therefore, we need to look at how the scope of the respective regulations and directives interact. We need to protect the individual and their private life. They need to have their private and personal data protected, but they also need to be able to take up offers, for example, which may interest them, and they need to be free to access the internet and avail themselves of opportunities which exist, which interest them. If they can't do that, then we've deprived them of their freedom. It may be that they need to pay something, or they may need to require certain items or get some kind of loan. Well, if we are precluding them from doing all kinds of things via the internet by having such stringent data protection arrangements in place, then we're not actually doing them a favour. We are actually depriving them of their right to free personal development and fulfilment. And this is therefore an encroachment on their liberties rather than an enhancement thereof. We need to allow people self-determination, the right to determine their own destinies and to be responsible for themselves. So all these points, I think, come in when you're talking about the need for consistency and a mechanism which will guarantee that, as Jan-Philipp has just done. He's explained at some length some of these very important fundamental points so that we can manage to put together a comprehensive set of arrangements which will apply at European level and which will be generally applicable. The one-stop shop, I think, is an excellent idea. It's a very reasonable and sensible proposal, and it could indeed be instrumental in achieving the very goal we've just described as our desired objective. But we can't expect data protection arrangements to resolve all the problems that arise, because there are many more than that we have to deal with. Because in this whole field and area, there are other fundamental rights which come into play, which are important in a different way. And therefore, as I said before, it's a question of balance. And that's what we need to achieve. This is what we are striving to do here, to balance differing, conflicting to some extent, concerns. And we can't simply be shelving our tasks and leaving it to others to resolve issues which we think are too critical or too controversial. Because if we do that, we'd be running a severe risk of data users or data managers taking on our task for us and simply deciding themselves on what balance they want to see. And this may not be the best one from the point of view of the citizen. So what Jan-Philipp Albrecht has suggested is very reasonable, but I'm not sure that it will necessarily guarantee the achievement of the balance which I, as a legislator, would be seeking to bring about. We've also got to look at issues such as direct marketing and form a view as to what we should be doing on this. For example, we need to have more information, I would contend, on the full impact of regulating an area such as direct marketing. We might be creating a whole lot of additional problems, and I suspect that this is something we should be discussing in some detail. I think the rapporteur has not put enough detail into the recommendation as it currently stands. That's fair enough, we're at an early stage, but we do need to build on this and flesh out further points of detail. I think others think that the whole issue of profiling is invariably a negative one. But here we have a very widely compiled definition. And in terms of the scope and impact of the legislation, the impact on somebody wanting to write to their clients might be considerable. They might actually have to differentiate between a first-time client and a regular client. And this is the sort of thing that might actually be covered by profiling. And it might be difficult for the company to manage that. So the questions such as these types of definitions are very important, and we need to make sure that we have a practicable and appropriate set of definitions to make the legislation workable. I think we've also got to see whether there is actually a way in which we can define the boundaries in the case of some sort of abuse, for example. What about the right to resile from an arrangement is somebody able to do that in the case of an abuse which emerges within the course of a month? But it isn't always possible to do this. We need to recognise that too, and therefore we need to consider what sort of arrangements should be put in place to cover that eventuality. The right to be forgotten. Again, we need to find a technically feasible solution. I'm sure we all aspire to achieve this, but the question is how best to do so. It's only possible for us to regulate data which is supplied on a voluntary basis. We've got data breach notification arrangements, and here it's a question of looking at whether we're going to reduce the time frame which is specified, or whether we're also going to look at the gravity of the alleged offence and try to do something about that, and perhaps have differentiated time periods for different gradations of alleged offence. The question of self-regulation on the part of industry is also extremely important for commercial data protection and data usage. Obviously, this will have an impact on the companies, on the way that they work, and on their respective responsibilities. They've obviously got to produce documentation, and they need to have a clear legal framework to be able to do that. This brings us on to some other ancillary points. I've talked already about the question of definitions. Well, we will have a data subject we have to consider, I would argue, what we're going to do about defining personal data, singling out legitimate interest and all the various aspects here, and see whether we have actually already reached the objectives we had set ourselves and whether we can go any further realistically. It is extremely important for us to realise the import of what we're doing. And I think sometimes it can be the case that our approach is perfectly correct and perfectly defensible, but it just doesn't go far enough. So the data is not regulated in an appropriate way, and it's not available to a company in a useful way because of the restrictions we've imposed, not all of them necessarily for an appropriate objective. We'll have other opportunities to talk about this, so I'll leave it at that, and I'll come back to it at the shadow meeting. And I'm sure there'll be a lot of further points of detail that we'll need to discuss in the future. In conclusion, I think that there isn't as yet the balance that I'd like to see here. The citizen has a dual function for us in this legislation. We need to offer them protection from the negative and adverse impact of technology, but we also need to allow them the freedom to use it to their best interests. Thank you.
Ja, vielen Dank.
Thank you very much. First of all, I'll come back to what Mr. Albrecht said just at the outset. We're not actually starting right from the outset here. We're starting from initial arrangements on which we're going to build. And there are a lot of stakeholders here. There are a number of groups and individuals and bodies who are already operating Commission proposals. And there are others who are trying to have their say, who are in fact creating the impression that the instruments we're discussing are completely new and that are unnecessarily rigid. There are others who are also trying to dismantle protection standards so that they can argue as time goes by and as the debate evolves. A lot of this is all far too new and far too complicated and isn't realistic or practicable. So we need to see exactly what is going on and what the background objectives are of some of these stakeholders. To come back to what Mr. Foss said, I have actually a different opinion from him. Of course, there are many in the area of the electronic media who use advertising which is free and who like to take up offers of which can also be for free. But here we've got to ensure that we have acceptable arrangements in place, because if I want to order books and I want to order my vegetable box on the internet, that's not a secret, but it is my personal business, and it may well be that I don't want this information to be made available to another 3 firms or to anybody else for that matter. then there will be other citizens who don't care. They think it's fine if the data is passed on because then they'll get lots of other offers from other suppliers, manufacturers, operators, economic players. Therefore, the citizen has to be free. But you can't say that the citizen has to be free, a citizen is free, and then you establish a rule which means that the citizen is not free to decide whether or not their data is passed on to a third party. So we need to decide whether there has to be explicit agreement for every single type and instance of usage of personal data, or whether a generic approval can be given, and what sort of arrangements are appropriate for companies to be operating, and if a company that sells a number of different things, for example books or also travel packages, has got to seek separate authorization from the individual for each type of information it is obtaining. Then there's also the question that sometimes information is not free, and sometimes the difficulties that arise can be quite substantial. Sometimes books are being offered for free apparently, but sometimes these offers are not what they seem. Sometimes there are actually charges imposed. They may be less than they would be on the high street, but they might still be a charge, and this may not have been made clear to the individual who is under the impression that they're getting a service or an item for free. And apart from anything else, you're also submitting your data, and the company's perception is that your data is valuable to them, and therefore you, even if you were obtaining a service apparently for nothing, this is not the case, and individuals must be aware of this. If there's a provision that every time the individual has got to give their acquiescence, and the companies on occasion will turn around and say, well, this is going to undermine their whole raison d'etre and their business model. But this surely cannot be right. And it can't be right that a clothes company or a tailor could be sending our personal details onto some other company that's supplying greenhouses or whatever, and they will then be supplying the address lists and the personal data to yet another set of internet companies, all of which engage in direct marketing, all of which are approaching clients. And therefore, even if we're going to throw some of the booklets and the magazines into the recycling, nonetheless, some people will actually act on the basis of this sort of approach. Therefore, personal information is valuable, and it is not appropriate for this to go unregulated, and it is appropriate for individuals to be able to find out what is happening with their personal information. I agree we don't need to impose too many restrictions. I think that in general, though, far too few citizens have any idea of what is being done with their personal data, and I think this is a much greater difficulty than them not having access to the rights that they want. We also have got to consider things like the right to resile from a contract, rights of complaint in the event of the goods supplied being substandard. Sometimes it's extremely difficult if you've ordered something online to find out how to send something back or how to complain. And you often have to do so by post, even if you order online, and therefore it is extremely difficult that you won't find anyone on the other end of the telephone. It is really very difficult for the customer. So there can be a very unbalanced relationship between the operator and the individual citizen. And we should be legislating in the interest of the individual citizen to make sure that we're affording them the protection which they legitimately deserve. And therefore, when we're putting together a new text, we want to have appropriate levels of protection afforded our citizens, and we want to have the arrangements framed so that in future internet operators are not able to exploit loopholes where there are the fewest controls, checks and the least scrutiny. So we want to make sure that we can provide a harmonised and reasonably uniform set of arrangements which will give citizens the protection which they need and will protect them from illicit operators and fly-by-night traders.
Thank you very much, Madam Chairman. Apologies for my voice. I'm not the rapporteur, and I confess I just want to talk on one particular subject which on which I've had representations from rather alarmed academics, and that is the interaction of Article 9, I think, with Articles 80 and 83, and in particular the rapporteur's proposed amendments, which I have, as I say, had expressions of alarm about the possibility of curbing academic research about which could touch on health, it could touch on political opinions or religious opinions. I mean, one can think of loads of examples in the last decade, for instance, rendition, torture, war in Iraq, where certainly political opinions would be a matter of legitimate comment and inquiry, not least to hold people to account or to ensure the application of the rule of law. And I think I find some merit at first glance in the concerns that have been expressed to me. For instance, particularly, for instance, Amendment 336, that sensitive data can only be processed for research only with the consent of the data subjects. One can think of loads of scenarios where the data subject would very much not like not to have their opinions or their conduct commented upon in a way which could bring them to justice, for instance. And I'm not quite clear to what extent the the provisions on freedom of expression, where the rapporteur in Amendment 324 has, if you like, widened out the exemption from the application of data protection requirements by saying that exemption shall be provided whenever this is necessary to reconcile privacy with freedom of expression in accordance with the Charter of Fundamental Rights. And so that's, you know, that's good, but if you look at then Article 83, or I think 80 on health, one can wonder how researchers, you know, genuine, legitimate researchers, or indeed people who might be on the, I mean, where does journalism stop and research start? But, you know, stuff that we might want to come into the public domain, but where the data subject would never in a million years give their consent, because adverse conclusions could be drawn from the said research when it is publicised. So I will be looking at that more. And I mean, from what I know of the rapporteur, I can't believe that he wants to curb you know, academic inquiry. I realise it's pretty difficult to draft in this area to get it right without you know, opening perhaps the floodgates to the use of sensitive personal data. But I think it obviously would not be the correct result that we end up you know, putting padlocks on research or investigative journalism that we need to get out into the public domain, which is very much not in the interest of the data subject to have in the public domain, but it is in the interests of most of the rest of us. So I'll be asking him to look again at those and maybe suggesting some further amendments. Thank you.
Thank you. And now I turn to the Commission.
Thank you very much, President. Let me first of all recall that from the Commission point of view, the Council in Dublin last Friday was a good council. There were good discussions on three important issues, namely the household exemption, administrative sanctions, household exemption, administrative sanctions, and the right to be forgotten. We have taken away that there is largely support for what we have proposed. And, of course, we are ready to work further with the Member States and the Parliament to also bring the consensus into the necessary legal form. Let me now say a few words about the consistency mechanism and the European Data Protection Board, which is, of course, the central element to ensure consistency and also the core innovation of the regulation in comparison to the directive. First of all, let me recall that it was the Commission which has fought, including through procedures before the European Court of Justice, for the independence of national data protection authorities. So there can be no question of the Commission having the intention of undermining the independence of national data protection authorities. Quite on the contrary, the Commission itself is a body, the independence of which is spelled out with very clear words in the treaty, probably words so clear to an extent which you do not find for any other type of authority. And for the Commission, it is important to recall that mechanisms of peer review left only to authorities of Member States have a tradition of not working very well in the European Union. But the mechanisms which we have and which work well, such as in the area of competition law, in the area of telecommunications directive, in the area of air transport slots, are all mechanisms where independent national authorities work together, but with an element of EU participation. Namely, in all these mechanisms, the Commission plays the role which it has to play according to the treaty, namely to be the guardian of the common European interest. And it is for this reason that we have suggested a mechanism which does not allow the Commission, contrary to what is said very often, to overrule individual decisions of the national data protection authorities, but which allows the Commission to play the role it is called upon to play in the treaty and in all other mechanisms which work between national authorities, namely to represent the common interest and indeed also to ensure a good balance as far as this common interest is concerned between considerations of fundamental rights and considerations of the common market. We have serious doubts as to the legality of what has been proposed here. Indeed, we share the view of the rapporteurs and other members who have said we should build on what we have. And this applies not only to building on the tradition of data protection, but it also applies to the acquis of EU law as a whole. And what we have is a treaty which, following the demands of the Parliament, allocates in Article 290 and 291 delegated and implementing rulemaking to the European Commission. And in this mechanism, which has been set up in the treaty following demands of the Parliament plays a role, while what we have seen in the amendments, the Parliament would not play a role anymore in the implementing rulemaking of binding rules by the European Data Protection Authority. We would find it surprising if the Parliament ensures that there is no element of EU representation of the common interest anymore in this mechanism as far as rulemaking is concerned. Now, as to the individual case decisions, we do not believe it is possible to set up in secondary law a body of national authorities which takes binding decisions. It is for that reason that we have proposed a mechanism which gives guidance and which gives the Commission the possibility, within limits, to suspend certain individual decisions, but which in fine leaves the individual decision to the national authorities. Why have we proposed this possibility to suspend? Well, exactly to give an extra time to think about what the common interest requires. So we invite members of this committee to work with us to make sure that we also build on the good experiences of other mechanisms of EU law where national authorities work together with the Commission to ensure consistency, and that we work together to insert and to maintain an element of the common interest represented by the Commission in this individual decision-making system. Let me finally recall that in our proposal in Article 66(1)(b), the Data Protection Board has the possibility to address best practices, guidelines and recommendations to the national authorities, but these have to be, by the very nature of this body, non-binding. But let me also express our conviction that if this mechanism works well, and this mechanism stands in the tradition of the Article 29 working group publishing opinions on how the directive should be interpreted, if this mechanism works well, then there will not be very many individual cases which will have to be decided by the body, because clarity will be created ex ante, and this is what the citizens and the enterprises need. They need clarity on the law before there is an individual case. And at the same time, if this mechanism works well, there will be very little, maybe no need for delegated and implementing lawmaking according to the mechanisms foreseen in Article 290 or 291. Does this mean this mechanism is not necessary to be maintained in the regulation? Do we therefore not need empowerments for the Commission to work together with Member States and Parliament as it is foreseen in the treaty? We believe that would be the wrong conclusion. We believe the likelihood that the system we are setting up works well increases if all actors know that if things don't work, for example, if an individual DPA does not play along the rules, which are non-binding, Article 66(1)(b), well, then it is possible to lay down rules which are binding in the form of implemented and delegated acts. So we are inviting you to work with us to better circumscribe, to condition these delegated and implementing powers. Obviously, all key elements, everything which is essential, must be decided by the legislator itself. But what is proposed now would mean that all the concretization is left in the hands of a body which is not foreseen in EU law and which, in addition, would not work according to the guarantees which the treaty gives you in Article 290 and 91 to play a role in the concretization of the regulation. So we hope very much that we can work together with the European Parliament to ensure that the common interest, as represented by the European Commission, is maintained in these mechanisms, both as far as individual cases and also delegated and implementing rulemaking is concerned. Thank you very much.
Thank you. And now I give back the floor to the rapporteur, Mr. Albrecht.
Vielen Dank, Frau Vorsitzende, und vielen Dank auch an die
Thank you, Chairman. I'd like to thank all colleagues who have actually spoken up. I don't think it'd be worthwhile going into the individual points, all of them. I'm sure we're going to have some pretty tough debates still coming up. And to that extent, a few general comments perhaps. First, as I see things, it really is crucial that in the text from the Commission and our amendments, we look at getting the details specifically right, because there's a lot represented in those sort of detailed points. We've heard from the Commission about the mechanism to try and make sure there's consistency. But there's still the possibility of various points being looked at differently. And I think here in the committee we've got to look at this all very carefully, anybody who's interested. Because a lot of the points raised with respect to the Commission's proposal and are actually in what I'm suggesting. Very often, especially if you put together some of the points, you can see that it's mentioned personal data and pruning control, that sort of thing. For example, personalized data about people who have been perhaps sexually attacked or something, this sort of thing is very important. And we do have rulings, we have case law on this. And so far it's always been the case that we try to follow the rules to avoid personal identification so that data is anonymous. So direct identification of the people is not possible, especially if they've been sexually misused. But very often people can identify through bringing together lots of little bits of information. Information which is not considered to be personal, you can actually personalize it. So you've got to be careful. You can identify somebody through lots of unpersonal bits of information when you collate those. So given those sorts of problems, we've got to bear in mind all the new developments which you can see in, for example, online. Technical standards do not track. It should be easier if somebody surfs the internet to say whether he agrees or not to his information being used. You see, what we want to do basically is make it simpler for people to give their consent or not give their consent to the data processors. So, and we've got to have some sort of centre which is responsible for making sure this is done. But as we've heard, it's only possible if we get informed agreement from people to start off with. And it should be basically that people have to give their agreement, and it's not the exception, i.e. that if you don't do anything, your agreement is actually taken to have been given to the processor. You actually have to give your agreement for the data to be processed by the processors when you're surfing or online. These, I'm just trying to clarify what's involved. That's one. We want people to have a simpler process, a process where they are responsible for taking their choices, rather than having something where people are being tricked and basically the processors do what they want. I don't really think that would get to where we want to be. And one further brief comment. Baroness Ludford has already gone. She had to leave. But nevertheless, I'd just like to cover what she said because it's quite interesting. In particular, for research, we have to have special rules. It's in the public interests. But what we then have to define public interest. It's difficult. Above all when it comes to research and data processing. You've got to look at statistical collation of statistics in an anonymous fashion. You can't identify the person. If the statistics are collated was linked to identifiable persons, in particular sensitive data, it's right that we should have some sort of control. And the considerations raised by Baroness Ludford on freedom of expression of opinion are relevant. Also, when it comes to legal procedures, I think we have strengthened what we say on this. In 80, we have an exception to the rules where courts can implement what we have in Article 80. And the legislator obviously has to define the limits of and what we mean by freedom of expression. We've discussed that already in the committee. We want to make sure that it's simpler and clearer what rules would be valid here. But I don't know whether you can cover the whole issue of freedom of expression in a regulation on data protection. It has to be something which is looked at in parallel. And when it comes to legal procedures, if it's covered under law, and if research and statistical collation is covered already in laws, then obviously these laws should be things which simplify and enable rather than bring in further obstacles. That's what I want to say for the moment. It was good to have this discussion, and I'm sure in March we will continue when we have the amendments and when we have the opinions from the other committees. That's important for us. In particular, the opinion from, say, the Employment Committee when it comes to employment data. Thank you.
Once again, the deadline for tabling amendment 27th of February at noon.